and welcome to the afternoon session of the Court of Appeals. Mr. Hivner, would you please call the next case?
Jenny M. Ruzzene versus Dieontea M. Stewart.
Mr. Hay, are you on?
Yes, Your Honor.
You represent the appellant?
I do, Your Honor.
All right, are you ready?
I am.
All right, you're on.
Thank you. And I would like to reserve 3 minutes for rebuttal, please.
All right.
May it please the court. My name is Andrew Pate, and I represent Mr. Stewart, the appellant in this matter. This is a bit of an unusual case in that I'm a bit late to the party. As the court's aware, through most of this litigation, both at the trial level and at the appeals level, Mr. Stewart was pro se, and he recently hired me after a motion to dismiss filed by the appellee due to alleged deficiencies in his brief, which I responded to and am now presenting the oral argument. However, the court did not grant me leave to file an amended brief, so I'm operating under a brief that I did not write, was actually written pro se by my client, which is in a somewhat unique situation in which the pleadings are pro se pleadings and therefore entitled to the sort of what the Supreme Court has referred to as the sort of diminished standard of pro se pleadings, but I'm arguing this on the merits as a member of the bar. So I will conform my arguments to the brief. I'm not going to attempt to backdoor in any wild new legal theories or anything, but I'm not going to be making the exact same arguments that are found in the brief.
Let me ask you a preliminary question about this case. Tell me why it's not moot.
Why it's not moot, Your Honor?
Well, this was an order of protection that was entered for 1 year, and it expired by its own terms on January 30th of 2020.
Your Honor, I believe that my client is entitled to show that this was not raised on its merits. Having previous orders of protection is a matter that is relevant to future litigation. Anytime you fill out an application for an order of protection from the clerk's office, one of the things that you have to put is whether you have had an order of protection brought against you before. It's something that can be used for cross-examination or to impeach your testimony in that litigation, particularly in any litigation that may involve the same party. And given the history between these parties, I think that's not impossible to imagine. So I think that my client is still entitled to have, as a matter of record, this order of protection have never been correct, even if he's no longer under the impediments in terms of his capacity to contact the respondent.
Was that raised? Was that issue raised on appeal?
Was the issue of his entitlement to relief raised on appeal, Your Honor?
In other words, whether or not it would have any impact on him in the future, whether there's another reason other than the fact that the order of protection has expired by its own terms, isn't that an issue you would have to raise on appeal?
Well, Your Honor, I believe that my understanding is that the issue is fairly raised as to whether the order of protection was rightfully granted, and my client in his brief certainly raises that his rights were violated by the granting of that order of protection. Now, could I have phrased it more artfully if I had drafted the brief? I think I certainly would have, but I think that he has fairly raised the issue that his rights were violated by the improper granting of this, and I don't think that he bears a special burden to show that because of one aspect of the violation of his rights, that is to say, the actual impediments on his conduct has expired, that means that all of the other impediments that this places upon him permanently are not still relevant. It's similar to being able to get a criminal conviction expunged, and certainly the Court of Criminal Appeals hears cases all the time, from litigants who aren't in prison. In fact, I even litigated a case in the Court of Criminal Appeals earlier this year on behalf of a client who was dead. So certainly he wasn't attempting to get out of prison. So I don't think that mootness is fatal to this case, given the unique nature of orders of protection and the permanent record that they create.
All right, go ahead.
Thank you, Your Honor. So my client raises two issues in the brief, which will be the thrust of our argument today. First, that there was a photograph that was improperly authenticated by the trial court, and that's a reversible error in and of itself due to the prejudicial nature that that evidence had on the proceedings. But secondly, and that photograph will be a component of this, is that the evidence was not sufficient to support the order of protection in the first place. Beginning with the issue of the photograph. My client in his brief states that the photograph was not adequately examined by the court and that it wasn't properly admitted. And what that essentially amounts to, as I alluded to in my response to the motion to dismiss, was that it doesn't satisfy the requirements of Rule 901, which requires that the evidence be authenticated and shown that it is what the proponent of that evidence claims it to be. And the Court of Appeals has held repeatedly that the party is required to present evidence which demonstrates that the document is what they claim. And in that case, in this case, that was not done. The text message evidence isn't specifically anticipated in the examples listed under Rule 901B, but phone calls are, and other written documents are. And we have a lot of guidance from the official comments from the rule itself, as well as from past Court of Appeals cases as to how text messages are authenticated. And in this case, as in most, typically that's going to come through testimony of somebody who has personal knowledge about the writing and whether it meets the requirements. There's a case, well, a number of cases that cite to the Neil Cohen on evidence treatise in Tennessee. That's really the leading authority there, and that quote is from that treatise, that the particular writing or reading has to meet the requirements of the rule, and you have to have testimony from an individual who has knowledge thereof. In this case, we had extensive testimony in the case about spoofing of numbers and of potentially fabricated text messages. And these particular messages were authenticated, despite allegations that they were fabricated, through testimony of two witnesses. One was Ms. Ruzzene, the petitioner, and the other was a witness that she brought, Ms. Markham. And those are both reflected in the trial court statement of evidence that's in the technical record. And as the trial court recalls it, and as is in the record, Ms. Ruzzene testified essentially that she had no personal knowledge of these text messages, simply that the photograph was of her, and that she had not provided this photograph to anybody other than the respondent. Now, that's not a 901B4 issue where it's impossible for anybody but Mr. Stewart to have that photograph, because of course the proponent of the evidence herself admits that she had the photograph. So his allegation that she fabricated the messages at least passes the sniff test. This isn't something where it's top secret information or something that could not possibly have come from any source but him. But that's all she had. So we really rely on Ms. Markham, which, as the trial court points out, said that she received this text message, and she points to some phone numbers and identifies one of the phone numbers as one that's potentially owned by Mr. Stewart. But that's not enough by itself to bring this evidence in as to what it is purported to be, which is a text message that was physically sent by Mr. Stewart. There have been a substantial number of cases that have litigated the issue of how to identify communications that come from electronic devices, when accounts can be shared, devices can be shared, and that it's not conclusive. As recently as 2015, the state Supreme Court heard a case, State versus Thorpe, in which they looked into this. And in that case, they cared a lot about the fact that the type of communication, the wording and things like that in the text messages, were things that were part of a pattern from the actual person who sent the text messages. And the Supreme Court noted that the witness who authenticated the messages talked about how that was how he talks and that they've talked with him before. Plus, he also then later mentions the text messages in-person communication. So he essentially ratifies them through his own actions. And that all came into evidence. Here, we don't have anything like that. Essentially, we have Mr. Stewart who's denying that he ever sent these messages. We have only a witness who says that she received the message from a device that he was at least one of the people who operated. There's no direct evidence that he was the actual sender of these messages. And the content of the messages, being a lewd photograph, were obviously very troubling and upsetting. And so we believe they meet the standard for reversal on the basis of prejudicial evidence that shouldn't have come in under 901 in the first place and is not admissible, and therefore by itself is reversible error, because we believe that would poison the trier of fact, despite this being a bench trial. And of course, the standard for admissibility of evidence is de novo. Despite this being a bench trial, the judge is not entitled to a presumption of correctness under whether this satisfies Rule 901. That's a question of law. Moving on to the sufficiency of the evidence. Despite the prejudicial nature of that photograph, it's not tremendously relevant to whether the order of protection was rightfully granted. As the appellee themselves point out in their brief on page 8, the crux of this case is her fear of physical harm. The trial court was concerned with that as well, as the record reflects. But fear of physical harm can't just be an irrational fear. It has to be based on activities or actions by the actual respondent to the order of protection petition. They have to have done things that create a rational fear based on facts. In most of the cases that you can look at where this has been litigated, typically there is some sort of physical element or some sort of direct threat element where we see that they have some sort of reason to fear that they are going to either be physically harmed, or the statute also allows for them to fear restraint or damage to property. There were some allegations in the petition that was filed in this case that might have risen to that level, including an allegation that the vehicle had been damaged, an allegation that the respondent had driven drunk with the children in the car, but that's not found in the trial court's findings of fact. The trial court's findings of fact reflect that the testimony was that he called in a DCS referral, which she claimed was unfounded. I don't think we would be granting orders of protection simply based on availing yourself of DCS's reporting guidelines. The remedy for that is the entirety of DCS's practices, and you're even entitled to appoint counsel if the case is open. They smoked marijuana with a child, not something that reflects directly upon the petitioner. They knocks on her door at night. Nothing about him making a threat when he does that. Annoying conduct at most, maybe trespassing. And they attempted to take some Christmas gifts, which is fairly vague. The only thing that I think would rise to something that's even relevant under the statute, including the text message itself, by the way, which is not a threat either. And I don't think that's sufficient under 3601 to rise to the level of something that requires intervention to the level of an order of protection. That would be a very thin basis if it were the only fact alleged, and the rest of the facts aren't relevant.
All right, thank you.
Thank you, Your Honor.
Hear from the appellee. I don't think you're not unmuted.
Am I unmuted now?
You're good now. Go ahead.
Okay. Good afternoon, and may it please the court. My name is Guy Tustin, and I'm a student attorney at the University of Tennessee Legal Clinic under Student Practice Rule 7, Section 10.03. And I'm joined by my supervising attorney, Joy Radice, and we represent Jenny Ruzzene, the appellee. Your Honors, we're asking this court to affirm Chancellor Weaver's decision to grant Ms. Ruzzene's order of protection because there was not just sufficient, but there was extensive evidence in the record to show that Mr. Stewart's actions placed Ms. Ruzzene in fear of physical harm. Mr. Stewart's brief boils down to essentially appellate challenges to the trial court's determinations of credibility. Chancellor Weaver heard testimony from Ms. Ruzzene and determined that she was credible. Tennessee Code annotated 363605B states that a court shall extend an order of protection for up to a year if the petitioner proves an allegation of domestic abuse by a preponderance of the evidence, which is defined in 363601 as, among other things, placing an adult in fear of physical harm, and that's a subjective test. There is substantial evidence to show that Ms. Ruzzene testified that she was frightened of Mr. Stewart. After she asked him to leave her home, she deleted all of his text messages, blocked him on all social media accounts, but Mr. Stewart continued to text Ms. Ruzzene, even sending a series of text messages that demanded the repayment of previously paid rent money. In these messages, he told her that if she didn't give in to his demands, that she would pay for it. Eventually, she even had to block his number. Ms. Ruzzene testified that she was so frightened of Mr. Stewart that she did everything that she could to avoid him. She moved, she changed cars, she changed jobs, but Mr. Stewart continued to harass her, even after the temporary order of protection was put into place. He generated multiple numbers to circumvent her abilities to block him, and he also continued to call her place of work. And just 2 days before the order of protection hearing, with an ex parte order of protection in place, Mr. Stewart sends out a mass text message containing a screenshot of a conversation between he and Miss Ruzzene that contains a nude photo with the caption, "Your boy's gonna get her." That was a direct threat to Miss Ruzzene. Mr. Stewart attempted on multiple occasions to deceive Chancellor Weaver. He even attempted introducing fabricated text messages and had Miss Ruzzene read them out loud in court. Chancellor Weaver warned of the dangers of committing perjury multiple times. Yet even after Chancellor Weaver warned, Mr. Stewart initially denied that he sent the screenshots, the photo, the text, or with the caption. He didn't even admit to having a copy of the photo until he was confronted with that screenshot. And then he alleged that Miss Ruzzene and Miss Markham hacked his email, retrieved the photo, and then fabricated a text message to send to the dozens of people. Chancellor Weaver stated that based on this evidence, he was highly persuaded that the defendant intentionally lied when he claimed to not have the photo, and intentionally lied when he claimed to not have sent those text messages. Chancellor Weaver didn't just find that Ms. Ruzzene was more credible. Chancellor Weaver explicitly found that the defendant was not credible. Your Honors, pursuant to Tennessee Rule of Appellate Procedure 13D, this court reviews findings of fact of a trial court in civil actions with the presumption of correctness. Great weight is given to the trial court's factual findings that rest on these determinations of credibility. And as held in Mitchell v. Archibald, which is cited in our brief, the appellate courts routinely decline to second guess a trial court's credibility determinations unless there's concrete, clear, and convincing evidence to the contrary. Chancellor Weaver made explicit determinations of credibility. He was highly persuaded that Mr. Stewart intentionally lied when he said he had never received the photo, that he didn't have a copy of the screenshot, and that he lied when he claimed that he did not send those text messages. Chancellor Weaver found that Mr. Stewart was not credible. In contrast, Ms. Ruzzene testified that she was frightened of Mr. Stewart. She testified about all of the life changes that she had to make to avoid Mr. Stewart. And she testified that Mr. Stewart's text messages containing the screenshot with her nude photo and the caption, "Your boy's gonna get her," was a direct threat. And Chancellor Weaver determined that Ms. Ruzzene was credible and had met her evidentiary burden. It seems as if Mr. Stewart is asking this court to reweigh the evidence with hopes of a different outcome, but he has not provided any evidence, let alone clear and convincing evidence, which could be sufficient grounds to second guess Chancellor Weaver's determinations of credibility. The record shows that the trial court properly found that Ms. Ruzzene had proved her allegations of domestic abuse by a preponderance of the evidence and granted her this order of protection. Your Honors, many of the issues raised by Appellant's counsel today were raised for the first time at oral arguments. Appellant's counsel attempts to find places in Mr. Stewart's brief where these legal arguments can be found. For example, he points to pages 1 and 4 of Appellant's brief to identify this authentication argument. But Mr. Stewart failed to make a formal objection in the trial court in front of Chancellor Weaver pursuant to Tennessee Rule of Evidence 103. 103 says the error may not be predicated upon a ruling which admits or excludes evidence unless a timely objection or motion to a strike appears of record. We know that Mr. Stewart did not object to the authentication of this photo. He refuted its credibility, but he made no formal objection to preserve this issue for appeal. And we know this because it's nowhere in the statement of evidence, which by Tennessee Rule of Appellate Procedure 24 states is the fair and accurate, complete account of what happened in the trial court. In addition, Mr. Stewart's failure to adhere to Tennessee Rule of Appellate Procedure 27A and Rule of Court of Appeals 6 constitutes a waiver of his issues. So the issues that we've heard today about the photo not being authenticated and being prejudicial and not sufficient were not properly raised and they're waived. Which gets back to the crux of what is in front of this court today. We believe that Mr. Stewart's brief raises a sufficiency of the evidence and a credibility argument. And everyday chancellors are tasked with making credibility determinations, and we place great weight on the presumption of their correctness. But to address appellant's issue with authentication, we look to Rule 901, as he's mentioned, and 901 standard is evidence sufficient to the court to support a finding that by the trier of fact that the matter in question is what the proponent claims. She just has to show that it is what she says it is. And if we look to the statement of evidence, which is the record, we see that in paragraph 16, Chancellor Weaver makes that explicit finding in 9014B, as Mr. Pate has pointed out. He says, Ms. Ruzzene was able to authenticate the text messages based on their content. Subject matters only Mr. Stewart had knowledge of and photos that only Mr. Stewart had possession of. This is a screenshot. So a screenshot had to come directly from Mr. Stewart's phone. The screenshot was from a conversation that they had had prior. And so she was able to identify those text messages surrounding that photo as conversations that she had explicitly with Mr. Stewart. Chancellor Weaver found that Ms. Ruzzene's testimony regarding this was credible. Chancellor Weaver made substantial credibility determinations during the trial court. He found that Ms. Ruzzene had proved these allegations of domestic abuse by a preponderance of the evidence, and that granting of Ms. Ruzzene's order of protection was proper. For these reasons, we're asking the Court of Appeals to affirm Chancellor Weaver's decision. And if the court has no further questions, we ask that you affirm.
What do you say about the mootness argument?
Your Honor, there is no legal authority that shows that it's not moot, but there are we know that there is currently another order of protection that was granted against Mr. but it's not in the record.
Well, then we can't hear anything that's not in the record, Counselor, but this order of protection expired by its own terms on January 30th of 2020.
Yes,
so my question is, what argument, is there any argument that's been made by the other side in the briefing that would counteract the fact that the matter is moot?
No, Your Honor, there's nothing in the brief regarding that argument. So anything raised today is subject to waiver. It's the first time we've heard of it.
All right. Any questions? Any other questions? Thank you.
Thank you.
Pate, you have 3 minutes on rebuttal. You're moot.
Yes, I just figured that out. Thank you, Your Honor.
Okay.
Your Honor, the counsel for the appellee is only in the loosest sense even addressing the arguments that I've raised here. They really want to hang their hat on this idea of credibility, and it's easy to see why they would do that. They cite to valid authority that states that on issues of determining witness credibility, bench trial judges are afforded great weight, and so that's one of the strongest positions for them to be in, is to argue that we can't get a reversal based on improper determinations of which witness was credible. But that's not the argument that we've made, either in the brief or at oral argument today. We agree that she testified, Ms. Ruzzene did, that this was, a photograph of her, and that that he was the only one that she recalled providing that photograph to. But even if we were to stipulate those things are true, which we don't, but even if we did, the fact that she was determined to be credible for that, and that he was determined to be non-credible when saying specifically that the text message was fabricated, that doesn't mean that they provided sufficient evidence to allow the photograph to be authenticated. That's what we have raised, is that the evidence as presented is not sufficient, not that he should have called that particular witness a liar. And the determination of whether what's been provided satisfies the rule is a de novo question. And so we think that the court should view it under that lens.
What's the standard of proof?
Your Honor, the standard of proof for authentication under 901?
No, the standard of proof for the court to determine that the order of protection should issue.
Oh, preponderance of the evidence, Your Honor.
All right. And I assume what you're saying is that there was not a preponderance of the evidence. Is that your position?
Yes, either sufficient evidence to authenticate the photograph, which was what I was addressing, but they also didn't raise the preponderance of the evidence under the statute at all to show under 36.3.601 that we had abuse, which is what was pled and what's required. The fact that she perceived something to be a threat, it's not sufficient to merely allege fear. They're correct that it's a subjective test, but it's not enough to merely allege that you're afraid of something. Otherwise, I could get an order of protection against anybody I want by just saying, you know, so-and-so, I'm afraid of them, and not provide a reasoning for it. And I could prove by clear and convincing evidence that I think that by simply testifying to it. That'd be uncontroverted, but that's not enough to meet the standard. Our argument today is that simply attempting to take some Christmas gifts is not enough for an order of protection, and all of the other facts that were alleged don't actually go to the definition under the statute, which is a basis for a fear of harm or confinement.
All right, thank you. Thank you to both sides for your arguments today, and we will endeavor to get you an opinion as soon as possible. Thank you.
Thank you.
You're free to leave.
Nice.
Thank you.
This honorable court is now adjourned.